back, everyone. This is Mark Movsesian. I'm the director of the Mattone Center for Law and Religion at St. John's University in New York. And this is another episode of Legal Spirits, our podcast series on cases and issues in law and religion. You can find past episodes on Apple iTunes, Spotify, and other streaming platforms, and most recently on our new YouTube channel, which we launched just this year. So please like and subscribe. We've had a bit of a hiatus in Legal Spirits because, well, as I said, we've been setting up our new YouTube channel and also launching a new animated video series called Landmark Cases in Law and Religion, which I hope you've all had a chance to take a look at. But we're back now with a new episode that will be of great interest, especially to the law students among our listeners. Every year for the past 10 years, the International Moot Court Competition in Law and Religion has gathered teams from law schools in the US and Europe to argue a mock case before panels of judges representing the European Court of Human Rights and the Supreme Court of the United States. It's a fascinating opportunity for students who learn about the ways that these two courts address legal issues surrounding church and state. I'm talking here about establishment and public religion, state religious neutrality, free exercise and religious exemptions, and other current topics. The moot court is a comparative law exercise that's unlike anything else in legal education. Most of the time, it takes place in Italy. I've had the good fortune to participate personally on a few occasions, as a member of the committee of scholars that devises a new problem each year, as a judge, and for the first time this spring as co-coach of a team that the Mattone Center at St. John's sent to Rome to participate in the competition. So I thought it would be a good thing for listeners to hear from the two Italian scholars who established the competition 10 years ago and who have been most instrumental in keeping it going ever since, Andrea Pin and Luca Vanoni. We'll hear how Andrea and Luca came up with the idea for the competition, what the pedagogical mission is, how cases, teams, and judges are selected, how they decide where to host the competition, and future plans. As I say, I think this episode will be of great interest to the law students among our listeners, but also to law teachers who would like to involve students in this amazing opportunity. So let's introduce our guests. Our guests are long-term friends of mine and the Mattone Center. Andrea Pin is a full professor of comparative public law at the University of Padua. He's held visiting positions at universities in the US, Europe, and the Mideast, and has authored many books and articles on Catholicism and Islam, European understandings of state neutrality, and religious freedom in the Middle East. His current work focuses on human dignity, constitutionalism, and religion, the Christian legacy of European law, and the challenges to freedom presented by emergent technologies such as AI. Luca Vanoni is a full professor of comparative public law at the University of Milan. He's been a visiting scholar at universities in the United States and in Europe, and has written many books and articles on law and religion and comparative public law, including comparative constitutional law. He has a special interest in legal pluralism and constitutional interpretation and the separation of powers in the United States. Welcome to you both.
Thank you. Thank you for having us.
Well, I'm delighted to have you here. As I say, I think this is a fantastic competition and something that people really need to hear about. So let's start at the beginning. How did you come up with the idea of the International Moot Court Competition in Law and Religion? It's so original. As I said a second ago, I can't think of another competition like it. I mean, there are other moot courts that focus on church and state. There are other international moots like the Jessup competition in public international law and this competition in international commercial arbitration. But this competition is unique in that it focuses on law and religion and also takes a comparative perspective. So how did you come up with this? Where did you have any models? Luca, I'll start with you.
Well, I cannot take credit. The original idea was from Andrea, and it was since we discuss a lot about law and religion, we have common interest, then we share that experience. But the original idea came from Andrea's mind, and I think that the real issue here is find out a way in which we can share our knowledge with students from all over the place in a comparative perspective, and using law and religion as a tool to get in contact with people from other legal tradition. But I don't want to take credit from an Andrea idea, so I leave the floor to Andrea for that answer.
Okay, Andrea.
Okay, thank you. So the story is quite funny, because at some point there was this center in Venice. It was basically a foundation that was established by the then Cardinal Catholic Church. Angelo Scola still is a prominent intellectual figure. And I was approached by some of his stuff, and somebody said, "We have money, but we don't have an idea. Do you happen to have an idea?" Which is quite unusual way to start things, with money rather with ideas, right? But this is how story started. So we had the possibility of doing something that had been done before, especially in a European setting. It's quite remarkable, the kind of difference that exists between continental European and American and British law schools, I think, in terms of the experience of moot court as a proper part of training of lawyers. And so I thought it would be a good idea to have something of this kind. And a religion was actually something I was very much interested in. I developed a decade-spanning friendship with people like you and Luca, by no coincidence. And so it was natural to start with religious freedom. And after all, we realized through the years that a religious freedom is a perfect template to experiment both with the universality of a right and of a value, and at the same time realize how much religious freedom relies on specific constitutional, legal, and social setting. So it's sort of point where universality and particularity meet in quite a unique way. And so we've been doing this for years because it's just fascinating, as Mark knows and as Luca knows.
Yeah. Well, Andrea, it's interesting. So someone came to you with resources and said, you have a project you can apply this to. There are, I think, no official sponsors. No institutional sponsors for this moot court. Is that correct? It's more or less an informal thing that gets done every year. How would you describe that?
I don't know what Luca would like to say, but I can say that so everything is done.
Everything is
Everything is done and is possible thanks to the generosity and friendship of so many people who at so many different levels have been helping out with moot court. We can identify some big supporters, like, of course, the Fondazione Mattone, which jump-started the initiative, but also the International Center for Law and Religious Studies at BYU, of course, as being a big part of this. Then we had some help from the European Academy of Religion, and we had also the help of Notre Dame. Last time we did it was a Notre Dame facility, of course. ICLARS as well was very helpful. But, of course, if you don't have money, you won't go anywhere. But there's a level of commitment, of personal commitment, among so many people, including Mark Movsesian, of course, without which this wouldn't be possible. I remember spending hours with both of you drafting the case that would make sense both in the U.S. Supreme Court and the European Court of Human Rights. And that takes forever. It's always a rewarding experience because you have first-hand experience about how different um, decent legal settings can be when it comes to the protection of the same right. But and that was of course it was quite a challenge. That's always been the challenge.
Well, so I understand. So there are certainly institutions that provide financial support for this, for which, of course, we're all very grateful for that. But it really is, that's my experience, is it really is just a few people getting together and coming up with a program rather than an institutional sort of thing that, continues without people getting involved at a really personal level. So when you decided to compare European Court of Human Rights and the Supreme Court of the United States, how did you do that? I mean, so the comparative law question is always, are there enough commonalities to make comparison useful at all? So here you chose to have the European Court of Human Rights and the European Convention on Human Rights, and the Supreme Court of the United States, which would, of course, be applying American law, constitutional law, and statutory law. So how did you come up with that as the comparison here? Luca, you want to answer that one?
Yeah. First, let me add a little thing to what Andrea told you about the spirit of the competition. In my view, and that is an amazing opportunity because throughout this competition, I made a lot of new friends. And that's the reason why the competition is working, because getting involved to something fun with students and colleagues and judges and knowing so many different approach to law is what make me a good professor when I teach to my student. But I'm blessed by the idea that the people that I met during all this year became my friend, and I take advantage in some way from this friendship. So that's the reason why we wanted to run the competition every year, even if we don't have an institutional facilities and people and there is a lot of, as you know, Mark, there is a lot of work behind. But, when you're working with your friend and when you're working for students and to see how students are delight to compete in this competition, every work is easy. So that's my experience about this competition. And about the comparative law issue, my take, my angle, my perspective on this issue is that first, law and religion is a perfect right or freedom if you want to exercise yourself to a historical comparative legal approach. And because for instance, in Europe, when I start studying freedom of religion in Italy, all the people were talking about laicità, that it means laicité. At the very end, they were talking about neutrality. And sometimes if you don't go deep in the legal terminology of every legal tradition in historical perspective, you cannot realize how different is the way in which we're using the same term in Europe and US. So the interesting thing is we sometimes have in law and religion studies and field, we have the same issue, for example, the same religious symbol in Europe or in US or in some other place, sometimes even in the same place, let's say public space or a school or something like that. So the fact of the case are pretty similar. And sometimes scholars are using the same term in order to defining the proper solution of this case law. Let's say neutrality. But then at the end, if you're taking the comparative approach, you easily realize that the way in which European court or judges are using neutrality and the American system are using the same term is not comparable in the historical and profound meaning of the word. And so it was easy for us to say, well, when we have this problem, we have to look in different perspective. And so the moot court is quite interesting, because you can use the same fact and having different approach. And that's the reason why we decided to start with the US Supreme Court and the European Court of Human Rights. Also because back in the days, 10 years ago, these two courts were basically defining the boundaries of law, religion, and pluralism in the world. And 10 years ago, they are starting looking each other. And there was this kind of dialogue on religious freedom between the different judges, not just on religious side, but for instance, also the gay marriage was pretty interesting to see how the two court and the two different judges dealt with the same problem. And so we decided to start with these two different jurisdictions and compare them. And that's basically the idea. We start with that, and then we move on during the years.
That's it. I mean, Andrea, is the competition always in Italy? In my experience, it's always been in Italy, but maybe it's elsewhere too sometimes.
I would rather say that it needs to be in Europe for one simple reason, which is the funding for European universities usually is much less available than what is available to U.S. universities, just because of a culture of moot courts makes it unlikely that a university can subsidize European students the way U.S. universities can. Then that's our perception. Of course, we have frequently done it in Italy. We did it once in Cordoba, in southern Spain, which was amazing, because we were hosted by the Actors Association, the National Consortium for Law and Religious Studies, and that was the perfect time and place. And we have professors who were able to, and judges who were able to serve as judges for the moot court, and so we did it there. But we haven't vetoed any other possibility. It's just that it's easy to do that for us.
Well, it's delightful.
Usually, excuse me.
I was going to say, Andrea, it's delightful to come to Europe and participate in this. So I'm not complaining, but it has always been there. And you mentioned judges just now. So how have you selected the judges for the competition? Andrea, you want to take it first?
Yeah, of course. A part of it is because we wanted to engage judges or professors we thought would be interesting and knowledgeable, of course, about the matter of the case. But we also we have also prioritized friendship and personal connections, and the fact that since this is not primarily a matter of competition, but rather education, we have always preferred to contact and work with judges who share the same view. We're more interested where the experience that students can get rather than decide who is the best. And this is why, if I can just add one thing, this is why we never run parallel sessions. So we always have one court at a time. So each student can watch how the other court operates. We see this as one of the intrinsic benefits of the competition itself.
Luca?
Yeah, let me add a funny story about the moot court to explain what Andrea just said. In the first edition, I was just a coach of a student team. And my student at the time decided they want to apply for the U.S. Supreme Court. They say, well, you don't know nothing about the U.S. Constitution. I teach to you a little bit about the U.S. Constitution, but the U.S. Constitution is very, very complicated, especially First Amendment, especially law and religion. So be careful with that. Don't say, well, we don't care. We want to have fun, so we want to compete in front of the big guys of U.S. Okay. We didn't have a proper rule back in the time, so we basically decided that Andrea told me your student will have let's say 10 minutes to explain their view, their argument in front of the judges, and then the judges will start with question. But then the U.S. Supreme Court judges came and say, no, that's not the way we do things in U.S. We start making questions to students, and that's it, because that's the spirit of and the proper way in which the U.S. Supreme Court is doing the job back in our country. So my student didn't have this experience. I say, well, you remember I told you you have 10 minutes? Okay, forget it. You will start to having a lot of questions from different judges and so on. And they say, well, we will do our best to answer the question. They did a great job, in my view. And at the end, the judges, the judges that we selected back in the days, one of them was Judge Sullivan. Say, well, look, I'm very impressed that your student decided to go in front of the U.S. Supreme Court without nothing about the U.S. Constitution, but fighting so hard for legal pluralism and legal freedom. But we understand something then, that even the way in which you discussed in front of judges is part of the comparative approach of the moot court. And so maybe every year, my students were impressed about the style in which the U.S. Supreme Court judges are asking questions to students. And maybe, and sometimes I heard from American students that say, we are impressed about the way in which your judge were talking about general principle, and are trying to understand the statutory interpretation of legal boundaries using general principle. We do not do that. We have to stick to the text of the law. And so there's a couple of examples that explain that we learn during the competition how to improve the comparative experience, and also judges were amazing to helping us and to teaching us how a moot competition, a proper moot competition, can be run.
Well, I want to, and Luca, I want to second that, because I think coming as an American to this competition, it's really instructive to see how the European court does these things, because their judging style is quite different, as you say. And it's been my experience both as a judge and as a coach of a team, co-coach of a team, and even helping to do the case. I think the students really, really get a wonderful learning experience from this. And it's not just watching the arguments, it's also interacting with the teams from other law schools, from other countries, which takes place during the breaks and at sort of receptions. And I think that's a wonderful learning experience. Well, I'm sure many law students who are listening to this podcast would like to compete in the future. So where do the teams come from, and how do you select them? And Andrea, how would interested students find out more about the competition going forward in the future?
So in terms of being selective, we tend not to be selective. We tend to accommodate as many teams as we can, precisely because we understand that those who maybe don't fare as high as other teams need more education, need more exposure to foreign teams and foreign cultures, and so we tend to be very inclusive. There was just a few chances in which we had to turn down applications, either because there were very serious problems in the written pleadings, so they could not really properly present their case, argue in court, or because we had so many applications that we had to make selection, because we try not to jeopardize the structure which avoids parallel sessions. As I said, that was the only chances I can think of in which we had to turn down applications. In terms of submitting an application, sending an application to participate, we usually circulate the call in advance. One of the obvious ways in which we circulate the call is through the Mattone Center newsletter. So the best thing they can do, both to help the court and help the Mattone Center, is probably subscribe to it and make sure they check it out consistently. We usually send out the call in the fall, and we run the competition in the spring, which is we usually do. We had just a few chances, in which a few occasions in which we did it during the fall. So the competition is held in the spring. Usually we try to overlap with the spring break. It's always impossible to do that over the spring break of all the universities that compete, sadly. But we try to do that sufficiently far from the deadlines of exams, etc. That's what we usually do.
I see. Well, I certainly endorse listening to the Mattone Center podcast and website and reading the website. Luca, did you want to add? Luca, have you seen any pattern in the teams that come? Do they come from the same countries? Anything like that you'd want to add?
Oh, we had, of course, we have people that are coming every year, like BYU, for instance, or my team, January, from Milan. We also host the moot competition court in my university once. So I generally try to apply and to have students coming from my university, because I think it's very important for them to participate in learning the comparative approach, the unique comparative approach of the moot court. But we had, back in the days, we had wonderful experience with people from Moscow, sorry. It's pretty hard. And this year we have Ukraine and Budapest. We have people from Spain. We have people from, of course, several law school, Notre Dame, your law school, a couple of times, and then
also Britain.
Yeah, also Britain, right? We have a couple of 2 or 3 teams from Britain during the years. The real thing that is impressing me the most, and every years we try to teach to students that of course is a competition, and when you are in a competition you have to compete. But at the very end, the peculiar thing of this moot competition is not winning, is learning. Is learning making fun, is learning making friends. So, for instance, I quote the experience of Moscow, because it was interesting to me that the people from Moscow became very close to my student that year, back in the days, and they decided to invite my student to Moscow. Today is impossible to think about it, but that's one of the things that impressed me the most when I'm teaching law and religion. I think law and religion, generally speaking, and this initiative in particular, can bring people together, because this was Andrea was talking about, universal in particular, but it's also quite important in my view and in this work to express the importance of religious freedom throughout the world, and especially in our secularized society. But in general, I think is a great language to get in contact with people and with difference. And, I'm a curious guy, so I want to get in touch with other people. And that's the reason why I always want my student to participate in the moot court. So at the very end, guys, if you want to be part of this competition, it's because you want to learn and make a new friend. It's not about the prize at the end of the competition. It's about the experience of the competition itself. That's my take on that.
Andrea?
Yeah, thanks. If I can throw just some additional ideas about what the moot court is about. One thing is the possibility of experimenting with yourself and with others. It has been always a rewarding experience to see how much the judge strive to match the English of the students. Most of the students are not native, and that never comes up as a sort of handicap. It's never handicap because judges don't want to single out students because of their proficiency of English, which is very different. And it's always possible because you see judges who are thoroughly committed to do as much as they can to help students to learn. And the second is that students have always been very keen to throw themselves into the center of a theater and try litigate in another jurisdiction. So you have American students argue in the European Court of Human Rights or vice versa. And it's always very rewarding because by doing that, they realize firsthand how difficult it is to walk in somebody else's shoes. You don't realize that if you think in very general terms about religious freedom, about the rule of law, or about the compelling state interests that justify limiting religious freedom. When you get to the point of arguing in front of the judges, and it's not because judges are very, very sharp or because they try to stress you as much as they can. It's rather because they just ask you questions that resonate with certain legal culture, that students realize how important details are, not just in another jurisdiction, but also in their own jurisdiction.
Yeah,
it's a very rewarding experience.
Well, Andrea, I think that's a great place to leave it. I agree with you. It's been a very enriching learning experience for me as a judge in the past and as also a member of the committee that picks the problems and as a co-coach. I'm looking forward to future competitions. I want to encourage all the student listeners, if you have any interest at all, please reach out to me or to Luca or to Andrea, and we can give you more information about the next competition, which will take place in the next academic year. Meanwhile, I want to thank everyone for listening. This has been another episode of Legal Spirits. You can find past episodes archived on Apple iTunes, Spotify, other streaming services, and now, as of this year, on our YouTube channel. Thanks so much. See you next time.
Thank you.